Hey everybody, it's Jim and Mackenzie. Hope you're all doing well. We're going to go ahead and let people um, get into the room. And Mackenzie Simmons is here with me, my trusted sidekick. I am here myself. I am working from home. I'm on quarantine for the next couple days at least. Daniel, our friend from the office, will be hopping on shortly. He's on a call at the moment, but he will be here with us in just a minute. Let's see. For those of you joining us, why don't you, and Mackenzie, I can't remember, do the people who attend the event, can they see the chat, or is that just you and I that can see the chat?
I believe they can all see the chat.
Okay, well, everybody, let us know who you are, where you are, and whether or not you can see the chat. Then we'll know. Oh, I haven't let people in yet, have I? Did I let people in? Oh, yeah. Yeah, here we go. Mamadou, Theo, Sarala in Texas. Can you guys see the chat? Let me know. You can see. Okay, Lydia can see the chat. All right, so Sarala can see Theo. That'd be fun. Wouldn't it be fun if sometime like we had a session on I-130s and a couple met each other on our webinar? That'd be pretty fun.
Oh, Lydia's in St. Louis.
All right, so people are coming in fast and furious, so that's good. We got people all over the place. All right, so sounds like everybody can see the chat. Sounds like we have friends all over. And one last thing, if you wouldn't mind, just so we can do better at giving you advice, maybe just let us know why you joined the webinar. Maybe let us know what stage you're at. We're going to get to all the questions later. I'm going to do a slide presentation. I don't know if you guys have been to our prior webinars on lawsuits, but this one's dedicated to marriage-based green card cases. And so it'd be helpful for us to just get a sense in the room, sort of where you are in the process. What if you had to give us your knowledge level of how it works on a scale of 1 to 10, where 1's really not knowing much at all, and 10 being that you know all the ins and outs, that would be helpful for us. So if you could leave us a comment over in the chat about sort of where you are in the process, and maybe you might just be getting started in the process, or you may be sort of far along. All right, cool. Those numbers are helpful. Thank you, Lydia and Vincent. Everybody, please chime in. All right. All right. 7. Oh, Isaac knows his stuff. All right. Sarala Tawari just got married, so that's great. Beginning to file. And then I guess let's just do one more, because I'll know how to dedicate my time. Do we have more people here where the foreign national, that is the person who's not a U.S. citizen, are those people in the United States, or are they outside the United States? Give me a sense on that too, and that'll help me. We're going to go through all of it together. But while I get the slides up and running, why don't you... All right, okay. All right, so we got inside and out. Okay, great. We're going to cover it all. All right, so I-130 webinar slides. Here we go. And this thing's recording, right, Mackenzie?
Yes.
All right, cool. This will be one of our videos this week. So I can't make all my videos this week. I can't get into the studio. I've been banned from the office because my son has the coronavirus. And even though I told my wife that I'm running a webinar, she keeps texting me questions. There's another one. Hold on. All right. All right, so Mamadou remarried and was about to file the I-130. We've had a client named Mamadou, I think. All right. How to bring your spouse to the United States and why you should never do it alone. Well, I wouldn't say you should never do it alone, but pretty much you should never do it alone. We're going to get to all that. So let's go through the process. Let's talk about what's going on. I think Mackenzie kept in one of my favorite quotes from Khalil Gibran, just about love, just to get you all in the loving mood, thinking about your heart and the person that you care about, that you want to get to stay in the United States. All right. All right, so tell me if you know this love story. I need to expand this a little bit. There we go. All right, so what we're talking about today is when a U.S. citizen, or actually we'll talk also a little bit about when a green card holder falls in love with a non-citizen and they want to get married or they get married and they're ready to start their life together in the United States. And so having handled a lot of these kinds of cases, there are lots of moving parts when a couple wants to be together. And what do I mean by that? Well, there's the immigration piece. Yeah. So we're going to talk about sort of the process, the sort of the three different approaches to coming to the United States. But one of the things that's interesting on these cases, so just so you guys know, all we do is immigration. And within immigration, over 60% of what we do are spouse and marriage-based cases. So it's what we know how to do. It's what we're really good at. There's some other parts of immigration law that are a little more complex that we don't do a lot of. So this is sort of our bread and butter. This is sort of what we spend most of our time doing. And I would say this year, we're probably going to handle probably around 250 spouse-based cases in one form or another. But what I was getting to is that there's lots of moving parts. There's the immigration piece. There's the work piece. Like sometimes it's very important that the foreign national be allowed to work the whole time or to work as much as possible. Sometimes the number one concern is that the couple really, really, really wants to be together as fast as possible. Other times there's people that really want to, quote unquote, do it the right way. And there are different right ways to do it, but there's just sort of things that some people are comfortable with that other people might not be comfortable with. So we're going to go through all that stuff. And then, of course, there's options that you may or may not have depending on your loved one's ability to get a visa or those kinds of things. So with Donald Trump in the White House, there are concerns and things that make these cases harder than they have to be and harder than they used to be. All right, so there's all those moving parts, and that sort of impacts the advice that we give. And a lot of times we'll ask you, hey, listen, what is the most important thing for you? Like sometimes you see those lists, you know, you can have this and this or this and this, and you can mix and match, but you can't have all four. And that's probably what we're going to hit you with from time to time on this presentation today, and as we sort of talk through people's situations. All right. All right. Family-based immigration cases are under a lot of scrutiny. In fact, all of immigration cases are under a lot of scrutiny, but these cases in particular are subject to a lot of scrutiny. When you get a green card in the United States, that's one step away from becoming a U.S. citizen. It's the second to last step in you being able to stay in the United States forever, to vote and do all those things that citizens can do. I believe that it's actually harder to get a green card than it is to get your citizenship. There are lots of reasons why people may not get their green card, or they may be found to be inadmissible to the United States. And you'll notice on the green card application itself, there are lots and lots of questions about reasons why someone might not be able to come to the United States. And so in a lot of ways, it is harder to get the green card. If you get your green card and you follow the rules and you stay married, you can get your citizenship 5 years later. Now, it's still not a cakewalk to get your citizenship, but it's certainly something that's doable. that you don't have to, be afraid that it's not going to work, but you just got to make sure you do everything right. Mackenzie helped me with these slides, and she knows me and how I roll. This next point, USCIS will not treat you fairly. I think that's definitely true, especially now. USCIS views their roles as enforcers. Because you get to that high level of a green card that I mentioned, they view that everybody who wants to get a green card is lying and trying to cheat the system, that every marriage is fake, that their job is to root out fraud, and they're actually being rewarded and commended for the more denials that they make or the more mischief that they make. Now, I generally thought that was true in St. Louis for a long time, but it's especially true now under President Trump. And then, there's all these procedural hurdles that just sort of get you to pull your hair out. I don't have a lot of hair left, but if I had any left and I was going through this process, I'd probably pull the rest of that out. All right, as you can see here, the young lady is very frustrated. There are a lot of hurdles, right? So you have your filing fees, you have your fingerprints, you have what are called requests for evidence. So the number of requests for evidence, which means that USCIS thinks there's something missing in your file, something defective, that those have gone way, way up. We're seeing longer and longer delays. We're seeing more home visits. We're seeing second interviews. I've even seen third interviews. Excuse me, I got the hiccups. And we're seeing more and more Stokes interviews. So a Stokes interview is if Mackenzie's a U.S. citizen and she's sponsoring me for a green card and we go in for our interview, I go into one room and she goes into the other, or I wait outside while she gets interviewed and she waits outside while I get interviewed. And there's a lot of confusing information out there on the web. So that's sort of why we put this webinar together, just to sort of give you a sense of what you're getting into. So we can help, but we thought it might be helpful if I told you a little bit about myself. So that's me there in the middle. Those are our 4 kids. That's Ismail on the left. He's the one that just tested positive for corona, which is why I'm on house arrest. That's Yusuf next to him, to my right, with the Cardinals sweatshirt on. That's my Cardinal sweatshirt, by the way, that he took from me. Then our third son, Ibrahim, is the guy in the green sweatshirt. That's my wife there on the far right, with the sunglasses. And then that's our daughter, Noor. We went to Egypt last year. Amani is originally from Egypt. We met in law school. And that's sort of how I got involved in immigration. Amani and I passed the bar in 1997. I became a Muslim the next year. We got married in 99. I opened up our firm. And then as soon as I opened up the firm, people were always asking me, especially at the mosque, to help them with immigration cases. That's when we sort of started handling our spouse cases, and we really learned it on the fly. That was sort of at the end of the Bush administration as the transition into the Obama administration went into effect. We taught ourselves immigration law. All right. So there's 3 possible ways to bring your spouse to the United States, or 3 ways that a foreign national can get a green card based on marriage to a U.S. citizen. So I'm going to talk about each of these. And these are the internal names that we use, and they are combined with the names of the forms. So there's a fiancé petition. That's an I-129F. And then you have a marriage-based petition for an alien relative. That's an I-130. And we call them in our office an I-130 here. And that's if the foreign national, the beneficiary, the non-citizen, is in the United States. We call that an I-130 here. And if there's a foreign national that is overseas that is going to go through the consulate, a consular processing case, our shorthand name for that kind of a form is an I-130 away. Good job on these slides, Mackenzie. I like these. All right. All right, so the I-129F is for people that have not yet gotten married. So these are for people that want to sponsor their fiance in the United States. So let's say that Amani and I hadn't met in law school. Let's say that Amani and I had met when I was studying abroad at the American University in Cairo. And let's say that I came back to the United States and I was working and we hadn't gotten married yet, but we were thinking about it. and we wanted to bring her here to the United States to see if we wanted to get married. Now, there's some requirements with the I-129F. I don't know if you, yeah, okay. There's some requirements with the I-129F. One big requirement, obviously, is that both parties are free to marry, that either they've never been married before or they have been married before, but they are legally and finally divorced. That's one thing. Another thing is that you have to prove to the satisfaction of the U.S. Citizenship and Immigration Service that you and your partner have been in each other's physical presence at some point in the last 2 years. So the question is, on the day that you filed your fiance application, looking back 2 years, can you prove that you and your loved one, your partner, your fiance, that you guys have been on the same planet, the same part of Earth, the same part of the planet Earth, same city, and seen each other face to face, so that you can, that's a requirement. You have to prove that, unless there's some really extreme hardship. We have one case now where the young lady can't travel abroad, but those are very hard cases to win. You're most likely going to have to show that you are together at some point in the last 2 years. And the way you do that is with travel tickets, photos. You might need statements from people, but you need to prove that up. The other main thing that comes up in fiance cases is you both have to sign an affidavit. That's a sworn statement that says that within 90 days of arrival, once the foreign national gets the visa and comes to the United States, that within 90 days, the foreign national and the U.S. citizen will get married. You have to make that promise. You have to make that promise under oath, and you have to submit it with your application. If you don't submit evidence that you've been in each other's physical presence in the last 2 years, and if you don't submit evidence that you intend to get married within the next 90 days after arrival, the I-129F petition cannot be approved. And the application is filed immediately, originally, with USCIS, and they process it. Now, we've had fiance cases take 6 weeks. That was a long time ago. Now it takes about 7 or 8 months at USCIS, and then you have to deal with the embassy. So one thing to keep in mind with all these cases is that you're always dealing with two agencies, U.S. Citizenship and Immigration Service, and then the State Department. So the State Department hands out the visas, USCIS issues the immigration benefits and sort of rules on the validity of the relationship. All right, so if you have that loved one overseas, so if I wanted to bring Amani here as my fiance, I'd file an I-129F with USCIS. I'd get a receipt notice back, and then once that receipt notice, I have that, I can sign in for electronic alerts, and then I'm going to get an approval notice probably in about 7 or 8 months. Once it's approved, then my case goes briefly to the National Visa Center and then to the embassy in Cairo for further processing. The I-129F petition and application process does go along a little faster. You'll probably be together with your spouse more quickly if you do the fiance case. I've never understood why that is. I've never understood why the spouses of U.S. citizens don't come faster than fiancés, but for the most part, for the last 13 years while I've been doing this, except for one little, maybe year and a half, they've always gone faster. One of the disadvantages of this process is that what happens is you'll see when we get to the other case types that there's sort of an immediate green card that comes. With this, if I sponsored Amani to come from Cairo and she came to the United States, let's say that she gets her visa on September 1st, she comes on October 1st, we get married on December 1st, and then I apply for her for a green card and a temporary work card. She's not going to be able to work that whole time she's in the United States, right? So until she gets that work card. So that's from the day she lands through when we get married, through when we apply, and then 4 months after that. So you're talking 6 or 7 months where she can't leave the United States and she can't work. And so we call that, in that situation, we call Amani bubble girl or bubble boy. If your spouse can't work and they're on the shelf and they're stuck in the basement down here like I am right now, they might be getting a little wiggy and they might be getting sick of you. So you need to take that into account when deciding whether or not a fiance case is a good one for you. All right, so and I think some of the advantages and disadvantages of the fiance process will come to light as we show you the other options. Okay, all right. The I-130 here. So this is a scenario where the foreign national is in the United States. You can't file a fiance petition for somebody who's in the United States. If you want to file for an immigration benefit for your partner who's in the United States, you have to get married. And let's talk about being in the United States. So if the beneficiary is here, let's say that Amani and I were in law school together. Let's say that instead of her already being a U.S. citizen, which she was, she became a citizen when she was a little kid. Let's say that she's studying on an F1 student visa in the United States, and she and I get married, and we decide to get married a week before the bar exam. Now that would be dumb. No one would ever do that. But let's just say that we decide to get married. Well, once we get married, then I can file an I-130 petition for her. That's a petition for an alien relative. And there are an unlimited number of visas and green cards available for the spouses of U.S. citizens. So I could file for Amani, and after we get married, we have to be legally married. We would file the I-130 petition, and we would file a bunch of evidence demonstrating that this is a legit marriage. And then we would also file some other forms. So besides the I-130, which I would sign, and the I-130A, which is a background form that she would sign, other than that, we would submit the green card application, which is the I-485. And that's where Amani would be trying to adjust her status from an F1 student visa holder, which is a non-immigrant visa, to lawful permanent resident. So she's going from the low level of a non-immigrant to a green card, which, like I said, is one level below citizenship. And that's why they pay close attention to marriage-based cases, because someone's getting such an advantage and they want to make sure that the marriage is real. So we would file the 485, and then because that process takes so long, right now anywhere between 6 and 18 months, depending on which field office you're at, depending on that, you're going to also file an I-765, which is a form to get Amani that work card, and an I-131, which would get her advanced parole. Because while you're here and that green card case is pending, you can't leave. Amani couldn't leave the United States without this permission. It's called advanced parole. Parole means permission to come back into the United States, and advance means you're getting that before you actually leave. If you were to file all these forms and then leave without that, then the whole application is deemed abandoned, and you're probably going to have to consular process. So that's, and then there's some other forms that we'll get to, but basically you need to submit a medical exam at some point, and then you're going to need to sign the U.S. citizen is going to have to sign a form called an Affidavit of Support. That's an I-864. That's a form that shows that the beneficiary is not going to become a public charge, and that you, the U.S. citizen, will support them. So now, in the scenario that I discussed, we were talking about Amani having been on an F1 visa. But let's say that instead of an F1 visa, let's say she had come on a visit visa, and let's say that she had come in 2008, and then she decided that she just didn't feel like going back to Egypt. And so she overstayed her visa. And let's say that during that time, she had been working without permission. Well, this is one of the great benefits of marrying a U.S. citizen. And again, because it's such a great benefit, it's also something that is heavily scrutinized. And when it's heavily scrutinized, it's because when you marry that U.S. citizen, it clears up the fact that you overstayed that visa from 2008. And it clears up the fact that you've been working without permission. Now, what it can't clear up in and of itself is if you entered the United States without inspection. So that's a really big deal, entering without inspection. So the law makes a big difference between people who were inspected, that is, that they came on a visa and overstayed, versus people who were uninspected. That's people who snuck into the United States. If you were inspected and overstayed, you can adjust your status sort of simply by marrying that U.S. citizen, as long as it's all legit and not solely for the immigration purposes of gaining an immigration benefit. If your partner entered the United States without inspection, without permission, then it's going to be a little harder to get them a green card, and you might not even want to file, just because it could lead to them being put into deportation. So that's sort of beyond the scope of today. We might get a little bit to it in the questions, but just know that if your loved one, your partner, has been in the United States for a long time, but were properly inspected, then you should be able to get them a green card based on marriage. When you file that I-130 and the 485, your foreign national spouse at that point is going to be able to stay in the United States while the case is pending. They're not going to have to leave while the case is pending. And like I said, they're not going to want to leave until they get that travel document. So there is a lot of confusion right now about the public charge rule, but just know that you're going to have to demonstrate that it's unlikely that the foreign national is going to become a public charge or get government benefits. That I-130 process, like I said, it starts with you filing all the application and paying the filing fees. The filing fee currently for the I-130 is $535, and the filing fee for the 485 is $1,225. Those fees are expected to go up on October 2nd. So if you're thinking about doing this, you might want to get married and get this thing on file sooner rather than later. They're not going up that much, but they are going up. And then, so you file the forms, you get receipt notices back, you get case numbers, you can start tracking your case. And then your foreign national spouse is going to get a fingerprint notice. And then they're going to get fingerprinted, and then they're going to do a background check. And after the background check and 4 or 5 months expire, then they're going to get that temporary work and travel card while they're waiting for their green card interview. If your loved one, your partner, is overseas and they already have a visit visa to the United States, you might be able to do it while they're on their visit visa. But if you get married in those first 60 days, you're going to have a lot of problems. So you can't have immigrant intent when you're coming on a non-immigrant visa. So we would want to talk that through if that's something that you're thinking about. That's true also if they are part of the visa waiver program, if they're from one of those European countries or a country where the people can just come for 90 days. All right. And then the I-130 away. So this is the slowest process. It takes the longest. And again, you're going full sail with both agencies, USCIS and the State Department. So on this one, you just file the I-130 and the I-130A. So you're just paying the $535. And that's going to get processed at USCIS. There's no fingerprinting here in the United States on that part. That's going to get processed by USCIS, take about 7 or 8 months. Then it's going to take a month to get to this place called the National Visa Center. The National Visa Center is in New Hampshire, and it's the first part of the State Department that is going to look at this case. At that point, you have an approved I-130 from USCIS. They have validated the marriage, and now it's all about paying the visa fees and getting a decision from the State Department as to whether or not your partner is going to get that visa and get to come to the United States. After you're at the National Visa Center, you're going to submit a whole new set of electronic forms. You're going to pay some more fees, and then your case is going to get sent overseas to the embassy for your loved one's visa interview. We usually recommend that the U.S. citizen not attend the visa interview. Nothing really good happens at the visa interview. I'd rather have the foreign national go and do that by themselves. Again, you have to be legally married to be able to file the I-130 away. So a lot of times we'll have situations where somebody goes overseas, gets married, and then comes back, or they meet in the third country and the U.S. citizen comes back, and then we file that I-130. We've also had situations where the U.S. citizen has been living outside the United States and they want to apply to bring their loved one back on a green card. Those cases are a little bit tricky. You have to reestablish residency for the U.S. citizen sort of before or during that process, and we can talk about that too. So there's a typo in the slide that says you should file the I-130 here. That should be the I-130A away. So the I-130 away you would do when the foreign national is overseas. So you don't have to submit the financial evidence until you actually get to the State Department, and these cases can take a really long time in the State Department. The other problem with the State Department is there's a doctrine that's called the Doctrine of Consular Non-Reviewability, which means that basically if a visa gets denied at the embassy stage, they don't have to tell you why it got denied, and you're not entitled to an explanation, and you can't really appeal it. So there you go. All right, so those are the forms that we were talking about earlier. Right now, we're not filing with the I-944. They've taken the form down, and they're not sure if they're going to bring it back, but it's still one of the forms. And then marital evidence. So marital evidence will hinge on how long the relationship is. You're going to want to show, obviously, details of the marriage, money that you spent, time that you spent together, any chat or emails between you and your loved one. Mackenzie, do you have that? Can you hop on the drive and get evidence of marriage? Look for that pink pamphlet and throw it up in the chat so that people can download that for me.
Sure.
Awesome. And then, so these are the main forms that you're going to need. And just so everyone knows, we're going to send these slides to you with my discussion after I think tomorrow in about 24 hours, you'll get it. So you'll get all the slides, and there you go. All right, so that picture is funny, and it looks sort of funny. We probably have somewhere, Mackenzie, some photos of some forms that we have actually sent, and we have sent applications that are at least that high, so probably about a third or half of as high as that lady. We don't send them with folders. I mean, one of the things about working with our firm is we know how they like to receive it. So part of it is about organizing the forms in the way that they like to receive it. These forms are all sent to a USCIS lockbox where, excuse me, government contractors open the files and sort of start processing the case. So making sure that you get your filing fee in correctly, your photos and everything else properly, that's good. Just real quick on photos while I'm thinking about it. Don't ever send like Kodak Walgreens photos. You want to put, if you're going to send in photos, the best way to do it is to get a 8.5 by 11 piece of paper, put 2 photos on there, and then put a little description under each photo what it is. Send in color, spend the extra money, make your application look nice. Don't just throw a bunch of crap in the file. You'd be surprised at how crappy some of the files I've seen are. Even ones filed by lawyers. So that's sort of sad. All right. Speaking of having people send your forms, don't use a notario or an immigration forms expert. I'd rather you do it your damn self than to have some notario or fake lawyer do it. Don't use a fake lawyer. Either spend the money or do it yourself. We talked about the interview. Yeah, you can wait. I'd say anywhere from 8 to 16 months for your interview. At your interview, what happens is you're going to show up at USCIS. You're going to have your interview notice. You have to get through security. Then you're going to wait. This is for a green card interview here. So if somebody did a fiance case, one of the other things about the fiance case is you don't have to submit an I-130 once your loved one comes and you get married, but you do have to submit the 485 and the work card and all that other stuff. And you're going to have to prove up the marriage at the green card interview. So at a green card interview, you're going to go to your local USCIS office. They're going to have your file. They're going to go over your applications. The 2 main questions are, 1, is this a real marriage? Do I, the immigration officer, believe this marriage? And number 2, is the foreign national a good person that we want to give a green card to? So those are sort of the 2 main inquiries. And that's what the interview spends most of its time doing. It's going to be about 45 minutes to an hour, and they're going to sort of just ask you about your life and everything. So most field offices, most immigration officers will get 8 interviews in a day. So they work an 8-hour day, so you can sort of expect. Some cases go faster, some go slower. I've had interviews that were 4.5 or 5 hours long. The officer will go over all the information in the application. They do have gotcha questions. And like I said, if they have suspicions, the spouses will be separated. Things that cause suspicion are large age gaps, multiple marriages, If the U.S. citizen has sponsored someone before, that might draw a separation at the interview. If the U.S. citizen got a green card based on marriage and then turned around to sponsor someone else, that can cause trouble. And again, like I said, I don't like it when the U.S. citizen goes to the embassy interview abroad. So one of the cool things about immigration, I used to do insurance defense, and we would fight over damages, and we would usually settle most cases. In immigration, you either win or you lose. It's sort of a zero-sum game. So most people think about the approval, they think about the denial, but they don't think about these two things in the middle, which are the request for evidence and the delays. And those can be caused by mistakes in the filing, mistakes in what you say at the interview. We've done hundreds of these interviews. We've heard almost every question. So I think we do a pretty good job working with our firm. Once we get close and get that interview notice, we'll actually do a dry run, a fake interview with you and your spouse, where we actually go over the questions. They're going to go over every question on the 45. They're going to go over every question on the I-130. And we sort of get you ready for that and get your mind ready for this approach of dealing with the immigration people and answering all their questions. Basically, you want to be ready for every question. You want to be pleasant and smile and just answer the next question. You don't want to get in a debate or a fight or anything. Request for evidence we talked about. That's where they ask for more and more evidence. We've been taking over more and more cases when they get a request for evidence because they are so arduous. That reminds me real quick. I just need to text my wife. See, because we have that. We have a request for evidence that somebody just asked us to handle. Hold on one second.
While you're doing that, Jim, I dropped the marriage evidence checklist in the handouts section. So go ahead and check that out.
Okay, great. Thanks, Mackenzie. All right, there we go. All right. Now she's probably going to start texting me again because she thinks I'm textable. All right. I wouldn't do it alone. I wouldn't suggest doing it alone. I think that there's some things you can do, like maybe renewing a green card or getting an EAD, but trying to do something like this, it's pretty difficult. One of the nice things is that, you know, we sort of become a buffer for you. We help you sort of just do the work and then forget about it, and then you're just waiting. Frequently asked questions. Let's get to it. Can I get a tourist visa to visit while my case is pending? So if you guys haven't been to our YouTube channel, we have 600 YouTube videos on our YouTube channel. Mackenzie, can you drop the link to the YouTube channel or on there? I know there's more than one video about this. Generally, you're not going to be able to get a tourist visa to visit if you're doing an I-130 away case. Those are inconsistent because a tourist visa is a non-immigrant visa, and an I-130 away case means that you've said, I want to come to the United States and reside there, so you most likely won't get a tourist visa. All right, how long will it take? I think we've gone over that. We've gone over the times on that. Will I receive a 2-year or 10-year green card? Oh boy, that's a question we get a lot, isn't it, Mackenzie? So here's the rule, and here's how you think about it. The question is, after everything's been approved, and USCIS is literally sitting down to print out your green card, on the day they print out your green card, have you been married for 2 years or not? If you've been married less than 2 years, you will receive a 2-year conditional green card. If you've been married for 2 years and 1 day or more, you'll get a 10-year green card. If you're going to apply for citizenship, it won't matter that much. The only thing is that if you get that 2-year green card, so this is one of the ways, remember I talked about them being concerned about marital fraud and green card fraud. One of the ways they cut down on that is they don't just give you a lifetime or really a 10-year green card. They give you that 2-year green card. And at the end of the 2 years, you have to file a form called an I-751 Petition to Remove Conditions. Oh man, Siamani's texting me. All right, the I-751. Mackenzie, can you do me a favor? Can you Slack Laura Clark? Oh, she's gone already. All right, I'll just deal with this later. Forget it. All right, will I receive a 10-year green card? So at the end of the 2 years, you have to file an I-751, which is a a petition to remove conditions, and you have to submit more marital evidence. It's not as hard as getting the original green card, but and you most likely won't have an interview. They are starting to do more interviews, but you will have to submit more evidence to demonstrate that it's a real marriage, that it's still ongoing. You can file that on your own if you did get divorced, but those are tricky and are most likely going to need a lawyer's help with that. When should we get a co-sponsor? You should start. So if the U.S. citizen doesn't have 3 years of earnings history of making $30,000 on their taxes or around there, for each of the last 3 years, they're going to need a co-sponsor. And I would say you should start looking for a co-sponsor before you file. You don't want to do it after you file unless you're doing an I-130 away. If you're doing I-130 here, you want to have all that at the beginning lined up because you don't have to scramble if they ask you for it. If it's an away case, you can take a little bit longer, but you should start thinking about that. You need a U.S. citizen or a green card holder who's willing to promise that if the foreign national gets financial benefits from the government and that the foreign national can't pay it back and you don't pay it back, that they'll pay it back. What are some common reasons my case would be denied? Usually what we're seeing now is that they're saying that the individual was not free to marry. We're seeing this with a lot of divorces from West Africa, like in Ghana and in Kenya. We're also seeing cases get denied if the person isn't admissible for some kind of crime. We got pushed back recently on a Communist Party case that we had to sort of respond to. So they're definitely trying to be craftier on their denials, but I would say don't take their denials at face value. A lot of times they'll just throw a bunch of crap in the denial that doesn't really apply. And as you push back or appeal or sue them, then things sort of fall away. Those complaints fall away. Yeah, every I-130 case has to have an interview. If it's an I-130 here, you're going to have an interview here because they have to see the marriage and see how the couple is. If it's overseas, then the foreign national is going to have that at the embassy. Will my lawyer attend my interview? Well, I would say not for the embassy interviews, but for the interviews here. If your lawyer won't go to your interview with you, don't hire them. They're worthless. Either they're scared to go or maybe they charge too much, but you should not go to an interview without a lawyer. That's probably where, and lawyers don't necessarily do that much. I just think there's a lot more abuse and antics that happen when there's no lawyer involved. Can HLP take over my case after I already filed? Yeah, we could. We don't necessarily like to do that. We'd rather start from the beginning, but we can take over if you need our help. And as always, the sooner the better on that. These are just some reviews that Mackenzie threw in there. If you want to look at our Google page, Mackenzie, if you could drop that down in the chat, people can check us out. We have about 250 5-star reviews, I think. So you might want to check that out just to see if we're legit. These are some of our clients that we've been able to help over the years with I-130 here's and I-130s away. These were all fun cases. And these people are all sort of like friends of the firm now. So that's fun. The cool thing is, like, we get to help people get their green card, and then later we help them get their citizenship, and then we help them bring their mom over, which is sort of one of the fulfilling parts of what it is that we do. While you guys get ready, and Mackenzie, you get ready to start throwing those questions at me, I'm going to try to send that email to Amani real quick, and then we'll go from there, okay? Give everybody a chance to stretch their legs. All right. Maybe I didn't send it. Okay. All right. Let's get to it. How are we doing,
All right.
Mackenzie?
All right, so our first question comes from Mark. He says, is the process the same for an asylee granted asylum filing for his wife who is outside of the U.S.?
No, that's a different form. That's called an I-730. It should be more streamlined. It's not always more streamlined, but it's relatively the same. It's an I-730. But if you got your green card, then you're going to need to file the I-130. So that would depend on what's happened since you got your asylum. But it's pretty similar.
Mamadou says, should I file for our child, or does she automatically get in if he files for the child's mom, his wife?
Yeah. So the child might be a U.S. citizen depending on how long the U.S. citizen parent has been in the United States and how long ago they got their citizenship. But if the kid is not a U.S. citizen by operation of law and the this is a sort of a tricky thing. If a U.S. citizen is sponsoring their spouse and their child, a U.S. citizen has to file a separate I-130 for the wife or husband and then for the child, one for each person. On a green card application, if the children are underage, they would all be included in the parents' I-130. It's very strange, and it doesn't seem fair, but that's the rule.
Okay. Nadidi says, for an affidavit of support to support the I-130, USCIS requests 3 years of tax returns. What should I do if I do not meet the income requirements for the past 3 years, but I have a current income which meets requirements?
You're going to need a co-sponsor. You can try it with your current income, but almost always they're going to ask for a co-sponsor.
Okay. Michael says, well, I'm not sure if that's Michelle or Michael.
Sure. Michelle, probably, yeah.
But they say, married to a U.S. citizen within the U.S., is there a premium fees to expedite the green card application? I'm scared to wait so long without being able to travel or work.
There is a thing called premium processing for some kinds of immigration cases, but not for anything related to spouse cases. There's no way to make that go faster, unfortunately.
Okay. Tootie says, we provided pictures, a picture book, letters from people who were with us. Our first sponsor was disallowed, and they haven't acknowledged receiving the paperwork containing the information about our second sponsor. What should we do?
I would be a squeaky wheel. I would bother the crap out of them. I would see if there's anything you can do to make it go faster. But until then, I mean, unless it's been absurdly long, you'd want to sue them. One of the things that we didn't really talk about, and that's actually the subject of a different webinar that we do, is we really help people who've been screwed, who've been waiting a really long time. We sue USCIS and the State Department for delays on these kinds of cases. So if your case gets beyond processing times of 18 months or 2 years, you're probably going to want to go ahead and sue them. And then that's the other way to get the case moving.
Okay. Olga says, I'm Ukrainian and my husband is American, but we both live in China currently. Where do you think we should submit our paperwork to?
So on that, I would have the U.S. citizen go back to the United States, establish a home base in some town, get a bank account, a library card, proof that you're going to be there. Because if you don't do that, then they're going to say, well, if the U.S. citizen doesn't live in the United States, why should we give the spouse a green card? So they need to do that first, and then you would apply at the lockbox for whatever city that person, where their case is supposed to go.
Erica says, how is the process for green card holders? If I file right now, will that affect my OPT application?
So that's a tricky thing. It shouldn't affect your OPT. You can. So when you're married to a green card holder, some of the things that I talked about are a little bit different. The good thing is that for the first 10 or 11 years that I practiced, there was a delay. There was a backlog on green cards available for the spouses of green card holders. That delay is not current, and they are processing those cases as they come in. The only thing to think about is that the person with the OPT, the person who's not the green card holder, they're going to have to maintain their status all the way through the process. So that might be a little bit tricky, might be worth a call to see. It's not as straightforward as when there's a U.S. citizen involved. Those are a little bit tricky.
Okay. So Salman has an interesting question. They say, can my future daughter-in-law apply for special provision to come to the United States for the wedding for a few days after we petition? My son's a U.S. citizen. Her parents are green card holders.
As I always say, you can try, but I think it's unlikely.
Alexandria asks, when the petition is returned back to the U.S., how long does it take once reaffirmed and heads back to the consulate for the interview?
So that's a great question. It's very frustrating. If I was standing by the wall, I would bang my head on the wall. But basically, what's this person's name?
Alexandria.
What Alexandria is talking about is a situation where USCIS has approved a petition. They sent it to the State Department. State Department has had an interview. The interview did not go so well. State Department says, we don't really like this case. We're going to send it back to USCIS. And then USCIS affirms it. So they would send a notice of intent to revoke. They would say there's something wrong with this I-130. They give you a chance to respond. And then if it gets reaffirmed by USCIS, they send it back to the embassy. Problem is there's no deadline. There's no rule that says State Department has to listen to USCIS. And you are going to probably be waiting months and months to get the State Department to pay attention to the reaffirmed petition. Probably need to sue over it.
Okay. Rahel says, I was granted to stay in the U.S. through Asylum. I never applied for a green card, and I've been married for 10 years. Should I apply for a green card through marriage or Asylum?
That's a great question. That's going to depend on whether or not you were inspected. If you were not inspected, if you snuck into the United States or came without permission, you're going to want to apply most likely through Asylum. If you were inspected and have proof of your inspection, that's always important. You have to have proof of your inspection, proof of your lawful admission into the United States. Then you would just do it through the spouse because that's just going to be easier. You can expect that case is going to take a while. Right now, the Trump administration is looking at people who previously got asylum, and they're trying to say to themselves, can we go back and undo this now that we are doing their green cards, which is a really sneaky, evil thing that they're doing.
Rahman Preet says, what are the travel restrictions throughout the process of filing an I-130 here until you get the citizenship?
Travel restriction, really the only travel restriction, well, I guess there's a couple. One is that, you can't leave the United States until you get that work authorization and travel document card back, which can take anywhere from 4 to 6 months after you file. And then once you get your green card, you're going to have to stay in the United States. If you want to get your citizenship and you stay married, you're going to have to be in the United States for at least 1.5 out of the next 3 years. And you can't have any trips more than 6 months. So those are sort of the rules about that.
All right. Nita says, I'm a green card holder and want to bring my spouse to the U.S. who is in Pakistan. Is it okay if he comes here on a visit visa and we apply for a change of status here somehow?
No. Number one, you'd have to disclose that he's married to a green card holder, which means they'd most likely not give him the visit visa. But the bigger problem is he wouldn't have an independent basis to stay here while the green card case is pending. So that would be problematic. Unfortunately, you're probably going to want to just go ahead and file the 485. File the I-130. And then if you become a citizen, notify them, and then his priority date will become faster.
Sarala says, I came here February of 2020 on a tourist visa, which I have extended. We registered our marriage here in August. Would it be smart to apply now, or should I wait until I go back to my home country?
Do it all here. Unless you have some compelling reason to come. And as long as we can prove that you didn't have immigrant intent, that it wasn't your plan to come here and get married. And I think, excuse me, I think the coronavirus gives you a perfect reason as to why you stayed longer than you thought and decided to get married. There's no reason to go back unless you want to.
Okay, so Vincent has kind of a two-part question.
Two-parter.
So he has a 2-year green card, and he's a male. His U.S. citizen wife has been abusing him, and he is filing for divorce. It has not been finalized yet because of dividing the assets. He wants to know if he can apply for a 10-year green card if our divorce has not been finalized, or if he should apply with the I-751 waiver with VAWA.
That's a good question. If I were him, I would say forget the assets, get divorced as fast as you can, give up a little bit, turn down the drama, and get the divorce on file so that you can prove up the marriage and go that way. VAWA, for men especially, is a hard way to get the 10-year green card. I would say focus on getting the divorce done as quickly as possible, and then file as someone who is trying to get the 10-year green card based on a good faith marriage that just didn't work out.
Okay. Mateen says, I got married in 2018 and my wife is here now about 9 months, but she has an adopted child. However, I didn't apply for him. My wife is still in a conditional green card for 2 years. Can I apply for the adopted child now? FYI, the child is over 18 but under 21.
Yeah, so that's one I'd have to get out my little law book to look that over. I think generally you might be able to apply for that child, but that's something I'd have to look up. You can give us a call.
Okay. Yeliza Veta says, for the 3-year income tax return requirement, would assets such as properties be taken into account if the petitioner does not have 3 years of income tax returns yet?
Legally, yes. Realistically, no. It's very hard to get them to pay attention to assets. It's very hard to get them to pay attention to anything other than the income. The easier thing to do is just find a co-sponsor.
Okay. Lydia is actually seeking info to bring her mom. She's a U.S. citizen since 2018. Her mom has had a diversity green card since 2006, but in 2010, her green card was voided in the airport because she stayed in her home country longer than 6 months. Do you think this will have any repercussions for her applying for another green card, and does the process take a long time?
Process does take a long time. It's a lot like sponsoring your spouse. It's going to take about 1.5 years. They'll probably flag it and ask her about it at her interview, assuming that parents of U.S. citizens get to come back. Right now, Trump has banned that. But I think that it should be okay. She's just going to have to explain why she decided not to stay here. I saw a question on my favorite topic, just real quick, from Tootie. What is mandamus? I filed our I-130 in January 2017, and a decision has still not been made. Can my husband get a visa to visit? Or no, Tootie, you should sue them. That's ridiculous. 3 years is way too long to get an I-130 approved. I think we got time for like 2 more questions, Kenzie.
Keisha says, can I file for a marriage-based N-400 after 3 years while my I-751 is still pending? Does it slow down the process? Is it recommended? So
this is another one that I have a video on, and probably have multiple videos on, because this is something that I get mad about. I-751s used to take about 3 or 4 months to get approved. Now they're taking 18 to 24 months. So people are asking questions just like this. At first, we were telling people, go ahead and file that N-400 on the very first day. Now we're telling people, get the 751 approved first and then file. The reason is, excuse me, sorry. The files don't catch up to each other. They can't, they're just so stupid, and they're so incompetent at immigration that the system's not set up. They will send the N-400 for an interview before they send the 751. So legally you might want to, but probably not. Probably better just focus on the 751 and then file for the N-400, just to give yourself less of a headache.
Okay. Do you want one more?
Yeah, and Rahel's asking, when are we going to do this again? We're going to do this one about once a month, right, Mackenzie?
Yes.
Yeah, that's the plan. Yeah, we can do one more.
Okay, so Syed asks, my spouse is overseas. Do you think I can apply for an I-130 and an I-129F file together to expedite the process?
Oh, I'm glad about that. So that's what people ask about the old K3. Now, a couple things. Not that this is what they were suggesting, but you can only file one or the other. Don't file both. You're going to confuse them if you file both. Number 2, sometimes people will go over and get married, and then they come back and they'll talk to their friends, and their friends will say, hey, I heard it's faster if you bring them over as a fiance. So then they'll come to me and they'll say, Jim, we're not really married. Can I bring him as a fiance? The whole question is whether you were legally, well, I just looked like my sister when I said that. You have to play it straight. Don't be too cute. We've had more than one. I had 2 brothers from Afghanistan who both thought they were really, really smart. They filed these fiance cases, but they were legally married. And their spouses told them at the embassy that they were legally married. So you got to be careful. Don't be too cute. Just play it straight. Elizabeth, there will be a replay. This is going to get emailed out to everybody. For those of you who gave us a score as to how you felt you knew about the process. I'd love to hear some comments below. If you could leave us some comments about how you think this went, whether your scores went up, whether you feel more comfortable with the process. Hopefully we answered a lot of your questions, but leave us a comment as we sort of wind down. Let us know if you think this was helpful and if you think we should do this again. It was nice being with all of you. It was always good to be with Mackenzie. This was the very first spouse I-130 thing that we do. Every month we do an Ask Me Anything where people can come on and it's just an hour of questions. Also, we always do one a month on lawsuits. So if you found this helpful, please leave us a comment. Let us know. Glad you think so. Okay, good. I'm glad everybody's finding this valuable. We will send this out to everyone, and then also we'll post this to the YouTube channel in a couple days. All right? All right, cool. Thanks, everybody. Glad you're oh, Lydia went way up. I'm glad, Lydia. Lydia went from a 2 to an 8, I think. That's great. Al Hussein's a 10. Isaac's a 10. Nice. All right, everybody. I'm glad you feel empowered. You know, if you want to do business with us, that's just great. If you don't, I'm just glad that you got the information you needed. I hope, really, I hope that what you realize is it's pretty complicated and you probably don't want to do it by yourself. You know, one thing I didn't talk about is fees. So for our firm to work on a case like this, it's $5,000. So most people pay us $2,500 to get started, and then we charge $250 a month for 10 months because we're going to be together for a while. We try to make it straightforward for you and doable. All right, so have a great week, a great day. If you're a praying sort, give a little prayer for my son who's got the corona. We just found out, and hopefully I don't get it. And hopefully I can get out of this basement here pretty soon. All right, everybody. Thanks a lot. We'll see you next time. Thanks, Mackenzie.
All right, bye.
Thanks, Daniel. I know you're here. Thanks, buddy.